Good afternoon, everyone. Thank you for joining us today. Todd Harrison, myself, and Laura Rich thought we would have an update on the Modernization of Cosmetics Regulation Act. Since some of the deadlines are drawing near, we thought we'd just give some practical information for you as July 1st approaches. Laura Rich has recently joined our firm from the FDA and is very familiar and been tracking MoCRA very closely. This is a fireside chat. We received some of the questions from the audience already. We're looking forward to receiving more as we go through this. But with that, I will turn it over to Laura to introduce herself more thoroughly. And thank you, Laura, for helping us do this.
Oh, it's my pleasure. Thank you so much, Claudia. So I just want to briefly introduce myself to those of you who do not know me. As Claudia said, I'm Laura Rich. I'm of counsel here at Venable. I've been here a little bit over a year. Before that, I was at FDA for 17 years, and it's very, very exciting to be in a position where I can bring all that knowledge to bear for our clients. I also want to mention that I am a member of the FIDLI MoCRA 2024 committee. And a shout out to any of my fellow committee members who might be on this call. And I wanted to briefly mention that there may be additional webinars or seminars coming up about MoCRA through FIDLI in the not too distant future. So with that said, let's proceed.
And I also just want to mention today that Todd Harrison, whom all of you know, is here with us today, and he's available by phone. Thank you so much.
Yeah. So as you can see before you, we have a variety of items we would like to go over today. As Claudia mentioned, our goal here is not, even though you can see I have many, many papers in front of me because I never practice law through memorization. Our goal here is to really focus on the practical because a lot of this stuff is obviously written down, although this is a good time to mention that rulemaking is coming. So we really want to focus on the practical aspects of MoCRA and the upcoming deadlines and current and future responsibilities. So as you can see, what we want to talk about is just that in the second bullet. And we also want to talk about other things you should be thinking about, if not this second, definitely in the future. So of course, you are thinking about registration and listing, but you also want to be mindful of the need to renew and update as appropriate. So you're not one and done. This is an ongoing obligation. And one thing you want to keep in mind as you register and list is that your anniversary date, I understand, is the date that you register and list. So write it down. Don't forget about it because that's your anniversary date as far as I know going forward. It occurs to me that this may change in just for simplicity's sake, should FDA decide to make that decision, but remember your date for registration and listing because that's the date from which your future obligations stem. Adverse event reporting, very important, currently in place. So that's something we want to talk about with regard to your current procedures and do they need to be reviewed and perhaps enhanced. Safety and toxicity claims and the support therefore is obviously very important. And we want to talk about that a bit. Are they, do you want to take a second look and think about it? Have you reviewed your recall insurance coverage? As I'm sure you all know, there's no recall authority in this space. So you want to A, make sure you have recall insurance, and if not, B, consider getting some. And if you have some, C, consider whether or not it's adequate in this current litigious environment. Which brings me to my last point. Do not forget about the private bar. This is an opportunity for the private bar to be active in the space. Of course, it's already active, but even more active. And therefore, you want to be very mindful about that as you move forward with your MoCRA obligations.
Here we just have some high-level regulations that all of you know and have been familiar with and have seen. I know that I've been on the speaker circuit this season, and I'm sure many of you have been at many conferences. And I'm sure you've all heard before that, MoCRA is the biggest change to FDA's scope of regulatory authority since 1938. Every aspect of the cosmetic industry will be impacted by MoCRA. We are anticipating some GMP standards. Laura mentioned this already. The guidance document on GMP standards we anticipated at the end of this year. We have a timeline chart for you in a couple of slides from now, but we anticipate that there probably will be some delay. The registration and listing requirements are already outlined, and Their effective date is coming up in July 1st, the effective date. Adverse event reporting requirements, that's something that's new for the agency. I have some good questions for Laura about that, what that means for the cosmetic industry. Mandatory recall authority, FDA is taking safety very seriously, and they want to be able to respond very quickly. So this mandatory recall authority is something that the agency sees as a good tool to accomplish that. And there's going to be new labeling requirements, address information, fragrance allergens, once we sort of all decide what that means. And that there will be, FDA is going to assess the safety of PFAS in cosmetic products, which hopefully, although whenever the FDA assesses something, you're always wondering what it's going to look like. With all the litigation in this space, it probably will be a welcome assessment for us.
Hopefully.
Hopefully.
Okay.
So key terms, we've just outlined them for you on this slide for your edification, just as we discuss these issues as we move forward. You can have them in front of you. There's no need for me to read them aloud, but we just wanted you to have that information as we move forward in our discussion.
And here are the deadlines that we talked about. If you've seen some of our client alerts, we put this out with each one so that you know what their obligations are, whether they're in effect now or at some point in the future. Safety substantiation, FDA is anticipating that would be something that you would have on file today. The same with adverse event reporting and related record keeping. FDA is anticipating that you have standard operating procedures in connection with that. Labeling and professional use, all of that is in effect currently. The registration and listing are those two items that are coming up in a little less than a month from now. And then the labeling contact information went into effect or will go into effect later this year. Yes.
So let's talk about rulemaking. There's some rulemaking that is coming up. So the first one is current good manufacturing practice regulations. So the statutory date for this is December 29th of this year. We anticipate a delay. This is not to ding FDA. We imagine that part of the delay will be attributable to the inevitable delay when it's an election year. So we assume that this will be the case here. Everything will be subject to the pause that goes into effect mid-year when it's an election year. And of course, the effective date is supposed to be a year from publication of the notice of proposed rulemaking. But again, since the proposed rule is probably going to be delayed, it would make sense that the final rule will be as well. It's not unusual for FDA to sometimes run late with statutory deadlines, and we do indeed anticipate a delay. For the standardized testing methods for detecting asbestos, that was supposed to publish the end of last year. It's currently with OMB. OMB can review for 90 days, but they may ask for an extension, which looks like it happened here. That's, again, not unusual. And then the final rule is supposed to come out 180 days after the proposed rulemaking's public comment period closes. And so we'll have to see what happens with that. This might be a good time to mention that April, FDA came out with another report regarding asbestos. It's on their website regarding asbestos and talc. So that might be something. The FDA website has a wealth of information about some of these topics. So that might be something you want to look for. And if any of you have problems finding it, just email me. My email address is at the end of these slides, and I'll be more than happy to point it to you. Fragrance allergens is supposed to come out this month rather. We anticipate a delay. Again, it's an election year, and then the final rule is supposed to be published 180 days after the comment period is over. One thing that comes to mind is the effective date of these rules. We'll have to keep an eye on that. It's one thing, as you know, to publish the final rules. Another thing is the effective date. So that's something we'll want to be mindful of as we move forward and keep everyone apprised about. These are just our alerts that we've published recently, where you're welcome to obviously click on them, and hopefully it's good information for you. And again, if anyone has any questions, we're more than happy to answer them.
So those are just some slides to just highlight what's happening with MoCRA. In our day-to-day practice, we have found that we're getting lots of good questions in and around MoCRA. A lot of it is focused on July 1, the upcoming date, but there's other questions that are coming up first. But just to focus on, since we still have some time before July 1st, I think that you and I have talked a lot about, what should we be doing? What should we be thinking about? And how should we be handling the registration and listing issues? And so I think FDA has some really good guidelines about that. I think one of the questions we've had, so most of us are in a position who've already registered or will be ready to register for July 1. I think one of the questions I've had is, we're a little bit behind the 8 ball. What happens if I don't get registered by July 1?
That's an excellent question. So a couple of thoughts there. So number one, I think FDA is going to be a bit surprised as to how much information they're going to be getting in July. I think they'll be a bit overwhelmed. So if you don't get your registration listing information in, I think FDA won't be looking at you immediately saying, where is it? However, from my perspective, I just have to say this, it's a good idea to do so because it's kind of like everything else. You never get a second chance to make a good impression. And it's a good way to start off on the right foot. That said, if for whatever reason you can't move forward and get your registration listing in on time, obviously try to collect your data and submit as soon as possible. I doubt that FDA will be sending a warning letter if someone misses a deadline. I imagine you might get an email regarding the status of this information, but I highly doubt the agency is going to start, writing warning letters on July 2nd. So I would try to submit on time. If you can, I would try to submit as soon as possible. I wouldn't be too concerned about missing the deadline. I would just try my best to get it in as soon as possible and be mindful about the future submissions that you're required to make down the road. Because the thing I worry about is patterns. I mean, everyone misses a deadline, frankly, and everyone makes a mistake. We're all human. You just don't want a pattern of doing so because that's a horse of a different color.
Yes. So I think that as part of the slide when we were talking about registering listing, you made a very good point, Laura, about update as appropriate.
Mm-hmm.
So what do you mean by that?
So you have update obligations with respect to your registration information. So you need to update within 60 days. So you want to make sure that that's something I think the FDA will be mindful of. So you want to meet those deadlines. These deadlines are spelled out in the registration and listing guidance. So these are things you will want to do. And of course, you're supposed to register every 2 years and list every year. So you want to be mindful of those deadlines as well. And as I said, your anniversary date of filing will be your date you should submit your new submissions by.
And so the 60 days, just for clarification, it applies to like amended. So like if you done your registration and you made some changes of the required information,
Mm-hmm.
FDA is expecting that you let them know within 60 days of making that.
Yes,
amended.
it goes to any change,
Okay,
including
yes.
discontinuing. So
Okay.
any change you should amend.
All right. And what if you're no longer making the product that has been
That would be an amend. You would amend.
so you have to
as
let
well.
them know about cancellations as well?
Yes.
Okay. Okay. Perfect. You also mentioned adverse event reporting
Mhm.
procedures. I think that we're all used to adverse event reporting, but now the MoCRA gives us some details in and around that.
Mhm.
Do you anticipate that the reporting is going to really be different than other categories regulated by the FDA, say foods or dietary supplements or medical devices, for example?
So that's a great question. So yes and no. Yes, in the sense that, as I'm sure you all know, the definition has changed. So you want to be mindful of the new definition that exists for MoCRA and make sure you're aware of the definition and that there's exempt, and as the statute explains that you are allowed the secretary shall not consider a cosmetic ingredient or cosmetic product injurious solely because there are minor and transient reactions or minor and transient skin irritations in some users. So you want to definitely be aware of the caveats to this definition. But the bottom line is you want to be, so you A, want to know the definition, and B, want to be mindful about reporting when you consider it to be appropriate. And in addition, as I'm sure you all know, you have to report to FDA when it's a serious adverse event within 15 days of the event. And there's a continuing obligation with that if you get new medical information within a year. So this all goes to another point that we want to make, which is that your procedures obviously have to change to match the new requirements. And if you haven't updated your procedures yet, this is an awesome time to do so and make sure that they make sense, that folks are trained so they know what to do, that there's someone in charge monitoring, and that there's a responsible person who is in charge of reporting this information to FDA. So that was a whole mouthful of information there. So let me step back for a second. So what you, as you all probably know, the responsible person has the obligation to report serious adverse events to FDA. So A, you want to make sure that there is someone in place to fulfill that function. And B, you want to make sure that you have procedures in place so you can determine when it is appropriate to do so. Now, I think it's not as easy as perhaps I may have suggested, because there's a lot of information to consider when you make a serious adverse event to determine whether or not you should do a serious adverse event report. So you want to be mindful of that. There's not a whole lot of guidance out there with regard to this new obligation. My understanding is that FDA is not putting out a guidance on this topic. That's it's not on the current guidance agenda, so I'm not aware that this is going. You never know what happens next year, but to date, I'm not aware that they are. So this is something that you want to sit down with your colleagues, perhaps a counselor or two, and discuss what would be when reporting would be appropriate. And then of course, nothing happens if it's not written down, and it didn't happen if it wasn't written down. So you want to have written procedures in place to reflect those considerations and decisions. And make sure, of course, people are trained with regard to them, and just as if not more important, follow them. Because you want to show FDA, should they come looking at an inspection for related information, that you are in fact being consistent, you have procedures, you're training people, you're following your procedures, all of that. So there's a lot to do in this space. It's all certainly doable, but it's a question of, you want to make sure you have those ducks in a row.
Thank you, Laura. And you mentioned something that I was going to touch on briefly, but before I do, because I do want to get us to talk about inspections and what we anticipate and what we should be thinking about when FDA might knock on the door. But I also found it, as I was looking through what constituted adverse event, I thought it was interesting that FDA specifically meant rashes as something that potentially could be a serious adverse event. And so I just want to make sure that, going back to sort of the beginning, that really looking at the definition and really understanding exactly what FDA anticipates be included in the evaluation and potentially triaged for reporting to the agency, they are taking things that sometimes we might consider to be a passing type of condition as something that could be serious. Right.
It's not so minor. And that this definition makes sense to me, frankly, because of the nature of the product. So I think it made sense that Congress did that.
Yes. And so in my experience, just in terms of transitioning, is that whenever FDA is conducting an inspection, adverse events and consumer complaints are the first place that they gather information and documentation in connection with. So are we anticipating that FDA is going to conduct inspections in this space relatively quickly? Do you feel like we have funding for this type of activity?
So I think that's an excellent question. So my understanding is that FDA is currently working on its compliance program. I don't think they have all the funding that they want the last time I checked, but I'd have to double check that. But the bottom line is FDA is working currently on this. And I think we can, so one thing, again, stepping back a minute, obviously a lot of the inspections would deal with current good manufacturing practices. And as we just said, that rule, obviously, the proposed rule isn't here. And then the final rule won't be final for a while. So I see this personally as an evolving process. Obviously, as the CGMP rule gets written and finalized, that would be part of it. This is not to suggest that FJA is going to wait until that happens. I do not see that happening. I just want to say, I just mentioned this because I see it as an evolving process, and that this is an excellent time to look around your plan to make sure that everything as it should be, should FDA inspectors show up in terms of the materials being used, the substantiation that you have, the cleanliness, procedures, all of that, to make sure that you're using what's currently available to be up to date and ready.
So I think we've been talking sort of generally and sort of big picture. We have a specific question that just came in from the audience. The identification of fragrance allergies. Once that becomes effective, we're expecting a little bit of a delay, as you talked about. Do we need to relabel our inventory, or would it only be effective for new production after the effective date?
So that's an excellent question. And I think the answer to that is going to be in the proposed rule. I would imagine, generally speaking, FDA, I mean, obviously I've worked there. I think generally speaking, FDA is a fairly reasonable agency. I can imagine that they would give people time to implement the new label, I should say. So I don't think everyone's gonna have to throw all their labels in the trash and spend a lot of money whipping them out quickly. I imagine there'll be a transition period. That's reasonable. I think FDA has shown flexibility to date in the implementation of MoCRA, as evidenced by the delay of the registration and listing deadline. So I would imagine that they would continue to do so with regard to new requirements.
Absolutely. I agree with that. And usually it's very rare for the FDA to ask you to, abandon, inventory.
Yeah, I can't remember, in terms of regulatory requirements.
Yes, exactly.
As opposed to other situations.
Exactly.
I can't.
Well, if it's adulterated, that might be
Right,
different.
we're not going there.
Yes, exactly. Exactly.
So in a general regulatory framework, I can't imagine the agency be like, oh, well, now throw them out. I don't see that happening. I think there'd be a reasonable period of time. And while we're at it, since we're talking about rulemaking, I encourage everyone on the call to obviously read the proposed rule, which I'm sure you're going to do anyway. And if you think that's a good comment to make, I want to, as someone who used to do rule writing at the agency, I encourage you to do so. That's why the docket is open. So if you read anything that you think, wait, that's not reasonable, or I need more time, or whatever it is, this is a great opportunity for you to submit a comment to the docket saying what you think the FDA should also consider in moving forward on this path. So I want to encourage everyone to do that. I know as a rule writer, I read all your comments. So please don't feel that you're submitting in the void and no one's going to read them.
Yes, I think that's interesting. Another question that we had, this is also being practical. This is going back to product listing, Laura. So if you're managing ingredients, is it possible that an ingredient name will have no Unicode?
Yes, so that's entirely possible. I think if you look at FDA's website, it will tell you that not everything has a Unicode. So if you don't have one, I wouldn't get upset. It's not an indication of like you're safer than the next guy. FDA says that on its website. And frankly, not everything has a Unicode. And last but not least, it's voluntary information. So even if you have one, you don't have to submit it. So I wouldn't lose sleep over that.
Yes. And so one of the other questions I have in along this vein is some of the safety, and I know that we don't have time to go into what a safety dossier should look like and things like that, but do we have just a general idea of what the agency is thinking about in terms of what the safety substantiation looks like? I know we know the FTC standard. I know that we know what FDA is thinking about typically with safety products, but is there something special you're looking for in the cosmetic space?
Why, yes. So we did not practice that. There's a definition of adequate substantiation of safety in the the statute. So I don't want to read it to folks necessarily, but I totally encourage you to read it because I think it obviously has some very useful information in it. So it means tests or studies, research, analyses, or other evidence of information that is considered among experts qualified by scientific training and experience to evaluate the safety of cosmetic products and their ingredients. Don't forget the ingredients part. Sufficient to support a reasonable certainty that a cosmetic product is safe. And the term safe is also defined, and it means that the cosmetic product, including any ingredient, once again, is not injurious to users under the conditions of use prescribed in the labeling thereof, or under such conditions of use as are customary or usual. That's obviously not very new information. And then to Claudia's point earlier, the secretary shall not consider cosmetic ingredient or cosmetic product injurious solely because it can cause minor and transient reactions or minor and transient skin irritations in some users. And in determining it, the secretary will consider as appropriate and available the cumulative or other relevant exposure in the cosmetic product, including any ingredient thereof. So that's obviously a lot of words, but I think it's definitely something that you want to sit down with your team to determine whether or not you meet this definition. I know people have been discussing this and we've been talking to clients about it. And you might be interested in thinking about, well, because there is no guidance on this topic, where could I go? And some of the rulemaking preambles for the current cosmetic rules have some good language as to this. There's a draft guidance on tattoo ink that could be useful in this regard as well. So there's information, of course, there's ISOs. So that's available as well. So there's no need to despair. There's information out there to determine whether or not the evidence backs up your decision that you've met that test for safety.
Yes. Do you anticipate that FDA is going to evaluate the substantiation, the safety substantiation?
Oh, yes, of course they
Okay.
will.
Okay.
FDA is all about, I'm sure you all know this, FDA is all about safety. So
Yes.
they will totally be looking at that.
It's the first and last question the FDA asks.
Right,
Honestly,
right,
is about
right.
safety. So I think that this segues us to a good conversation. And Todd, if you're still on the line, I would love for you to sort of chime in. I think there's a couple of areas where the plaintiff bar is going to just pick up and start running with the new rules and regulations. And I think the safety data is one place. Obviously, the plaintiff's bar won't have access to your specific safety data, but just safety data in general in connection with specific ingredients. And I think that directions for use. And I think that I'm already seeing a pattern with the plaintiff's bar in terms of making safety assertions. And so FDA obviously regulates colors and color additives. And so even though they've approved it for cosmetic use, the plaintiff's bar is now saying, oh, it wasn't cleared for use around the eye area. So we've been getting a lot of questions and demand letters from the plaintiff's bar about whether the product, the directions for use, and the ingredient remain safe based on that.
Mm-hmm.
And so, Todd, I'm sure you've seen some of that as well.
Yeah, excuse me, I'm sorry. Yes, I've seen some of that. I think what I've seen on the plaintiff bar, though, is an uptick of plaintiff attorneys starting to argue that cosmetics are not actually cosmetics and that they're unapproved new drugs. We've seen that around dietary supplements and claims for supplements over the years, but not so much on the plaintiff side, on the cosmetic side. And I expect that on some of these moisturizing creams and wrinkle claims and things like that, we're going to probably start seeing an uptick, especially if FDA does like they do on the supplement side and starts issuing courtesy letters regarding claims.
Mm-hmm. I completely agree, Todd, that I think that one of the things about this registration and listing, I think that there is a risk that FDA might start asking whether certain cosmetic products are in the proper category. And I definitely think the plaintiff's bar is going to ask these questions, and they're already asking the questions. Go ahead.
Are you One thing I worry about is that plaintiffs bar may just buy products off the shelf and start testing them themselves. Do you have any concerns along those lines?
Oh, absolutely. And they're doing it now. So so they're already doing that. I have a couple of inquiries on my desk right now. One about the appropriate directions for use based on the ingredients in the product. I know that the cosmetic industry is very used to using like natural and sustainable and clean, and clean has so many different implications these days, and the plaintiffs bar is taking it very seriously and challenging those types of claims. So I think that with the ingredients being listed with the FDA, I think that there's going to be, you won't have to go out and buy the product as a threshold. You could just sort of look at the ingredients in one place and then decide, oh, well, maybe I'll challenge this, that, or the other.
Mhm.
So I do feel like, the FDA is going to be one aspect of it, but I think the plaintiffs bar is really going to turn up its inquiries into the cosmetic industry in a very real way.
Right, I totally agree.
And they will cite these letters or anything that FDA has out there that they send as proof that that's the position. And as we all know, warning letters or things like that are not considered final agency action. And the agency can easily make an assertion. Whether they're correct as a matter of law may be a different issue, but once they make that assertion, the plaintiff attorneys will glob onto that and state that's FDA's. The FDA has said that these are unsafe, these are illegal, these are unapproved, or anything along that lines, and we'll rely on that for bringing actions against companies.
I think that's absolutely right. And in other areas, we're seeing that day to day. The other area that I'm worried about, and Todd, I know that we talked about this briefly. I think that this is going to be an area that's ripe not only for PFAS, but I'm also worried about increased Prop 65 inquiries as a result of some of the transparency that the new rules allow for.
Well, and that's a whole set of other issues, because even on the food and supplement side, we're starting to see people getting noticed at 0.55 micrograms of lead, where for years we would never see notices like that. So the Prop 65 bar is getting more and more aggressive in California.
That makes sense.
Yeah, and the reason why I bring it is because when that fragrance information has to come out, I just feel like that's going to be right for both safety issues and for Prop 65 issues.
Yeah, I think you're right. I think that's a good prophecy in the sense that I think it's accurate. Not good in the sense you have something to be happy about, but I definitely think that's an accurate prediction.
So we have another question from our audience. We mentioned while we've been sitting here, we've been talking about inspections and inspectors. And one of the audience members asked if that's only going to happen to manufacturers, or will it also happen to distributors? I think that we should anticipate that it will happen with both, that both manufacturers, or if your name and address appear on the product label, that we can expect that FDA will conduct an inspection, and that you should be ready for that.
Yeah, I agree with that.
Yeah.
I think that what people should understand is that, just because you're using a co-man to make your product doesn't mean that you're alleviated of all the good manufacturing practices as soon as we find out what those will look like at some point. Because FDA is going to hold you all responsible as well. So don't just think that, oh, that's my co-man's worry. It's your worry too.
It absolutely is your worry, and it's certainly, at the very least, to the extent that you do want to delineate between your responsibilities and the manufacturer's responsibilities, there's some good contract language and contracts that you certainly can put in place And we do that all the time for clients in terms of making sure that you absolutely know what your role is as a private labeler versus your manufacturer's role. And so that when FDA asks, well, where is this? Sometimes if you're able to show the contract and that's something actually that can be assigned to someone else, the FDA will ask the manufacturer about it. But it is your responsibility, because your name is on the product, to make sure that even though your manufacturer has the lion's share of the responsibility, that you have done the appropriate auditing, you have record keeping of that auditing. So I agree with Todd. You cannot just, say, oh, it's my co-manufacturer's responsibility in total.
So I totally agree with everything you two said. I wanted to ask you, what about asking your co-manufacturer for additional testing for not only what's supposed to be in there, but also what's not supposed to be in there? Do you think that would be useful as well?
I think I do think that's true. And I think that type of question, Laura, comes up is when you're using these free claims. And so increasingly everyone wants to say their product is free of a certain ingredient list. And just because you're not adding it to the formula, at least in our experience with the plaintiff's bar, that is only carrying the bucket half the way there.
Mhm.
Some good testing that shows that you have data that the product is free of these ingredients is very important in some cases, depending on who the plaintiff's bar is.
Mhm.
Todd and I always joke about there's different quality of plaintiff's bar. Like some plaintiff's bar, we don't respond to the letter at all. Others, we respond and we know we're going to negotiate. Others were like, oh, we need to really pay serious attention to this.
Mhm. So test for not what only is supposed to be there, but what is not supposed to be there. And as Claudia said, this has to all be documented and you have to have the records. It's not enough to have a conversation about it. You need the record that this has in fact occurred.
Yes. So I have another question from the audience. Will there be a database of the registered facilities and the listed products? How soon will it be available following the July 1 deadline?
That is a great question, but I don't know the answer to that, frankly. We'll have to see. I'm not sure.
I guess one of the questions is like, what do you mean by database?
Well,
Because obviously it's going to be on the FDA's
right. So
the database, because we have to get it into the FDA, that's sure.
Right. So I assume they meant like on July 2nd, can you start writing your FOIA requests? Not that I'm suggesting that you do so, but in case you're worried about it. Yeah, I don't have information to provide on that topic. The second something.
So as soon as
to
we can
think
update it
Yeah,
about
we can
that.
provide an
We can
update.
certainly provide an update about that.
Yeah.
So I guess that goes into a question you and I talked about, and if you still want to talk about it in terms of what will be public and won't be public.
Right. So that's an excellent question that we definitely did discuss.
Mhm.
So that I just wanted to mention is specifically discussed on page 10 of the final registration listing guidance as to what will be available under FOIA. And the way I read this is that FDA, obviously there are FDA has regulations with regard to and FOIA stands for Freedom of Information Act. And FDA has rules with respect to that. And from the way I read this guidance, it's certainly going it specifically states it intends to make relevant information available to the public to the extent permitted by law. So I think they anticipate getting them and they anticipate fulfilling them as appropriate. The guidance does discuss what will not be available. So specifically, the product listing number will not be available for public disclosure. And as a reminder, that's the number you get from the agency. And the FDA will not disclose information from a facility registration on the brand names that are provided. So the way I read this is that you're not going to you will not be able to make a connection necessarily from the brand name to the manufacturer. And in addition, from the product listing, you can't get the facility registration number. So again, you can't do that cross link based on information the FDA, but a lot of this will be publicly available. Specifically, I'm talking about ingredients. So you want to be mindful of that as we move forward, which again is something I think the private bar will be carefully looking at to see what data they can glean and ponder how it could be used, frankly.
Perfect. So Todd, I want to go back to something that I think that a lot of the participants on the phone might be interested in is, I think you mentioned that the plaintiff's bar is going to be looking at some of the cosmetic claims of unapproved new drug claims. Do you have some specific examples that you could highlight just as a general proposition? I know that we all do a lot of claims work and we nuance it with appearance of or the look of type of thing. So I'm sure you're not talking about just, supporting the appearance of or.
Right. I think
Look,
things
yes.
such as, anti-aging, those type of claims, because that would affect the structure or function of the claim. FDA has over the years sent warning letters even over appearance claims, such as reduce the appearance of fine lines and wrinkles. But generally, the deeper the claims, such as minimizing crow's feet or deep creases and things like that, there are already those warning letters that sit out there by FDA.
Right.
But I think there's also a category of products that are coming out there that are not getting vetted. People are just marketing the products to market the products. And I think those are all kind of at risk if they're not truly claims related to beautification or odor control or anything like that. I think that, if we're just seeing a lot of novel products out there that I think are kind of ripe for plaintiff class action attorneys.
So Ty, let me ask you the next logical question on that. Since there's such a focus and, FDA is now becoming much more focused on ingredient safety and what the data shows and being proactive about it. Do you anticipate that FDA in the cosmetic space might say you might be using the right cosmetic parlance for example, but the activity of the ingredient is not cosmetic in nature?
I think that could be very well true, that you could look at it. So, I think the thing that we see a lot of is these new deodorant products out there that are probiotic based. FDA may take the position that that's affecting the structure or function of the skin, therefore it's not appropriate. So, I think those are the type of products that could run risk here with FDA and with the plaintiff bar. Part of the problem with, in my opinion, MoCRA and a lot of things is that a lot of our regulatory things are based upon outdated notions of health and wellness. And so trying to fit things into neat little categories such as cosmetic, dietary, supplements, food, drug, and biologics really don't work that well anymore. So but we're still kind of hamstrung by that system. And MoCRA doesn't address that. And so in many ways, one could say to the cosmetic industry, be careful what you ask for because you just got it. And you may not like the results that FDA starts serving up.
So that's interesting. So you're saying that because you see these definitions as somewhat rigidly applied?
It could. I mean, so if you think about it, is that if something, and we'll just take probiotic, for instance. Probiotics are being used for everything, just everything these days. And they're intended to affect the microbiome of the skin.
Right.
Okay. How are those products cosmetics? So if FDA takes the position that that what's the actual intent behind these probiotics, that they are to affect the structure or function of the skin, then you're no longer a cosmetic product. You're now a drug by definition.
I,
So
yeah,
those are the concerns that people should be worried about, because I think those are the type of theories that we're going, and we are, and I can always, in my practice, I've always started seeing these theories. These are not theoretical, these are actual demand letters.
Mhm.
So
yeah, it's true.
and they're already thinking about this, and they're already going there, and they're already saying there's ulterior motives. You now layer on MoCRA, and yeah, I'm not saying the FDA shouldn't have oversight over cosmetics. I think, quite frankly, they had that ability to have oversight over cosmetics without MoCRA, but putting FDA wanting more power, Godspeed, they got it. But when you start layering these things on top of each other, you're now, and you start getting warning letters, because understand, FDA doesn't use warning letters just to attack a company. They also, at the beginning of any new regulatory regime, they use warning letters to specific companies, really to highlight to the whole industry what they would like to see as compliance. The problem with that is that plaintiff attorneys use it against the whole industry.
Mhm.
It's true, and I think it's very interesting that it's not something that people talk about too commonly, that warning letters are not final agency action. And
Yeah.
it really is an invitation to have a dialogue with the agency, as opposed to that, you've made some major viation.
Mhm.
Oh,
Um,
and especially like with when they get the GMP settled and everything, the best way for FDA to tell the industry as a whole is to issue warning letters to companies that they find GMPs were not the way they should be. So it's not, FDA uses it as a teachable moment for
yes,
industry as well.
yeah,
And but yet that's not how plaintiff attorneys use it.
Right.
that's very
Right.
true.
That's a really good point, Todd. So you're saying what it's being viewed as the
I mean,
plaintiff's one thing.
maybe what we need is a law that specifically states that FDA warning letters cannot be used as evidence of a regulatory infraction for purposes of lawsuits. There
Well,
we
I
go.
think that I think we can, I think that's our, I think we can have it more specific, because it really, in order to sue the agency, you would have to go through, all of
Yeah.
your administrative remedies, and the warning letter is not considered final agency action, so you couldn't even sue the agency based on a warning
Yeah.
letter.
It's just
You
noted.
can't.
It's just
just
noted.
noted.
And I think that Todd has said it right. It's really a teachable moment. I know the industry doesn't view it that way, but going in and talking to the FDA every day, it doesn't always feel that way, but that is really what it is. It's sort of, I always say and talk in terms of, FDA is really a compliance agency. And if you demonstrate that you're willing and able, both of those things, to come into compliance, then usually the agency is satisfied. And the warning letters sometimes, we've been trying to quietly tell you, here's our opening, like, louder salvo to you, as to you need to start taking the agency serious on this.
Mhm.
Yeah.
And FDA has been really clear that, it has scarce resources, and therefore it's trying to be very mindful when it does issue a warning letter that it gets kind of the biggest bang for its buck in that regard.
I think that's right. This is an interesting conversation. I don't want to interrupt it, but I am being reminded that I failed to articulate the CLE code, and I will do it now. It is, and again, at the end of the presentation, Cosmetics 2024. That is Cosmetics 2024.
Thank you.
So Todd, you mentioned probiotics. I feel like probiotics, is sort of one of this category of ingredients that gets this, glowing receptions for consumers, and this bad rap from, other aspects of the industry. And they're pretty ubiquitous now. I think they are everywhere.
Yeah.
But I don't know that prebiotics or probiotics or postbiotics, whatever category, or all those categories, are the only questions that FDA might have about what is the true
Oh, no, I agree. I was just using that as an example.
I just didn't want people to walk away with that, because I also feel like there are some pretty, cosmetics have come a long way. I feel like there's the risk that some of the ingredients that are the most effective, that FDA could have the very same questions about those.
Yeah, I think that if you show like if you unless you say temporarily diminishes fine lines and wrinkles, FDA would say that by reducing the appearance of fine lines and wrinkles, what you're doing is that you're affecting the structure or function of the body. And just to hammer that point home, there's a very old warning letter to basic research
Okay.
over their strivectin product a long time ago. It's been at least 10 to 15 years. But basically everything that we on this phone tell our clients to do, they were doing, and FDA objected it to every last one of them. Now, so just keep in mind that they do on occasion, like every 4 or 5 years, will send warning letters out regarding these type of claims. And when those warning letters come out, then you're going to see an uptick on plaintiff class actions.
Right.
I think that's right.
I think that's right.
I'm just interested to see how this plays out with the FDA in that regard.
It's going to be a good. If you think about the ramp up with Dichet, which has taken almost all the 30 years since it's passed, I think the full impact of MoCRA will not be known for at least 10 years down the road, at least.
That makes sense.
That makes sense to me too.
That does make sense.
Although I think 10 years down the road is a good prophecy, Todd. I think that the difference between MoCRA and Dichet is that FDA was very biased against that group of products. I do not see the same bias with cosmetics. So
right, I agree with you.
So I think that some of what I consider to be just really hard charging and aggressive enforcement action that we saw early in the early days of Dichet, I don't think we're going to see that here.
I would agree. I think that the FDA will take more of a soft approach.
I would hope so, yeah.
But we'll see. But like I said, to me, MoCRA didn't fix some of the underlying fixes that are necessary to the law. Like, we really should allow structure function claims for cosmetic products. But that's just, they should have just done that. I mean, but that requires a whole redoing of the definition of drug and blah, blah, blah. So that's my pie in the sky wish list.
Well, I don't think it's that pie in the sky. I think it goes to a comment that you made earlier on this talk, Todd, is that we are dealing with some outdated and antiquated ways of working. And it does cause a little bit of, Cirque du Soleil type contortion in the industry. Because we all know that, even though we have to talk about, wrinkles on the upper layers of the skin or the surface of the skin, or moisturization only to, certain depths and things like that. Yeah. We all know that the products, are capable and do function much more intentionally than that. So yeah. I do feel like there's a bit of a fiction that we all sort of live with, and MoCRA was an opportunity to fix that. Well, we have 4 minutes left, and I just want to take a look and see if we have any other questions. Now is the time for you to send in your last minute questions as we close our little practical chat today.
Yeah, I'm trying to think of other, if we don't get a chance to answer your question today, if you just thought of it, 2:59 would be, more than happy to respond. Yeah, offline later.
So we do have a question about face and body gems and stickers. My daughters love these, where they're bejeweling their eyelids and corners of their eyes and things like that. Laura, you can correct me, and Todd, you can correct me. I don't think that those would be cosmetic products such that the facility registration would apply. But we can confirm that. I don't think so.
Because
Because it's not
I would argue they're general wellness devices, therefore there's no reason to still register the products.
I just think that they're consumer. Todd, that's hilarious. I think they're,
they make you feel good, but I don't know.
but I think that they're I think it's just consumer products. And so
Yeah.
I don't
Yeah.
know, but I think that that's something that we can certainly check on. But my gut feeling about gyms and body gyms and face stickers is that they're probably not regulated as cosmetics.
No, I don't think ear piercings are not regulated as cosmetics. So I don't see why these are non-permanent things. I think that would be a stretch.
I think so too.
Okay.
I really do think it would be. Now, obviously, since you're suggesting that people can put it on their bodies and on their face, I think there's some safety parameters that you want to make
Right.
sure that whatever adhesive, whatever is not going to cause some allergic reaction and things like that.
Particularly if you're putting them around the eye.
probably on the eye.
agency is very
Good.
concerned about products that go near or on your eye in the cosmetic space and other spaces as well.
Yeah.
Yeah.
And the last thing, and I'm going to throw this out there and we don't have time to talk about it, but I also feel like now tweens are getting into cosmetics.
Right. That's a huge issue.
And that's a huge issue. And I think that to companies, and it's a welcome audience. I have an 11-year-old daughter and she's never seen a makeup or cosmetic product she didn't love. So I think that it's a welcome audience. They're very entertained by it. But I do feel like that type of, if you're doing promotion in that area, the safety data that you need probably needs to be a little bit different than if your audience is 18 and older. And I also think there's some responsibility that we should think about in terms of advertising around that.
And state law requirements.
And yes,
Or
exactly.
potential state law requirements.
Exactly.
That's something to be, there was one, I think it's, the bill is dead with regard to how to sell, lotions to people, to minors. And my understanding that it isn't advancing in California, but that's something you want to be mindful of as well.
Yes. So I think we covered a lot today. Hopefully you got some practical information that goes along with MoCRA, since July 1 is a deadline. We're following these subjects very closely, both on the FDA side and the plaintiff's bar side. We thank you today. If there was any question that you had that didn't make it into our chat, please feel free to email us. And before we sign off, I want to give the CLE code one more time. It is Cosmetics 2024, Cosmetics 2024. Thank you and have a good rest of your week.
Thank you.